Welcome, everyone, to the 2021 Hudson Medal presentation. The Manley O. Hudson Medal, the Society's highest honor, has been awarded since 1959 to a distinguished person of American or other nationality for outstanding contributions to scholarship and achievement in international law. The medal has been conferred on many luminaries in the field, including Rosalind Higgins, Tom Frank, Michael Reisman, Ellie Lauterpacht, John Jackson, Bruno Sima, Peter Truba, and Justice Stephen Breyer. Before presenting the award to this year's recipient, I want to just thank Paul Reichler, Larry Martin, and ASIL Law Firm Leadership Circle partner Foley Hoag LLP for sponsoring this program, their 8th year of continuous sponsorship. And we'll hear from Paul shortly. We'll also hear from our honoree, who engaged in an informal conversation with Professor Lori Damrosch, a past president of the Society, who will have much to discuss with Bernie as they served as co-editors of the American Journal of International Law together for many years. And now for the medal presentation. Upon the recommendation of the Honors Committee, the Executive Council has selected Professor Bernard H. Oxman to receive this year's medal. Bernie is the Richard A. Hausler Professor of Law at the University of Miami School of Law and has been a global leader in forging, strengthening, and teaching the law of the sea and its application in the peaceful settlement of disputes. The award citation included the following quotation from the letter submitted in support of his nomination, and I quote, "Like Manley Hudson, Bernie has contributed to international law in many roles, as scholar, government legal advisor, and international judge, among other positions. And in all of them, his contribution has been distinguished. As assistant legal advisor in the U.S. Department of State, and as U.S. representative and vice chair of the U.S. delegation to the 3rd UN Conference on the Law of the Sea, he played a major role in the negotiation of the United Nations Convention on the Law of the Sea, and especially in the crafting of its path-breaking dispute settlement procedure. He stands at the top of the field today for more than half a century of contributions to the law of the sea and international dispute settlement. For his monumental contributions to international law as a scholar, judge, and arbitrator, the American Society of International Law is honored to present the 2021 Manley O. Hudson Medal to Bernie Oxman. Bernie, my warmest congratulations to you.
Thank you very much.
It's now my great pleasure to recognize Paul Reichler, who will introduce our Hudson Medal recipient and the discussion to come. Paul chairs the International Litigation and Arbitration Department at Foley Hoag and is a giant in the field. Was a highly regarded and experienced practitioner of public international law, specializing for decades in the representation in interstate and investor disputes. Paul, it's a real pleasure to have you with us today. Welcome, and over to you.
Thank you very much, Catherine. It would be difficult to overstate how happy I am that Bernie Oxman is this year's winner of the Manley Hudson Award, and how privileged we at Foley Hoag feel to be part of this presentation. Of course, we all know of Bernie's immense accomplishments over a truly stellar career. To recall them, we only need to review his CV, which is thicker than the Oxford English Dictionary, and I'm only referring to volume 1 of the Oxman bio. He has truly done it all. Preeminent scholar with a list of publications a mile long, outstanding educator who has brought great distinction to the learning institutions that have been privileged to have him. Judge ad hoc at the ICJ and ITLOS, the only American to ever serve in that capacity in both judicial bodies. Advocate for states before law of the sea arbitral tribunals. Legendary government lawyer for the United States, gracing the halls of the State Department and the Legal Advisor's Office, and of course, representative of the United States at the historic Third Conference on the Law of the Sea, which produced the Montego Bay convention, to which Bernie made immense contributions and supervised the production of the English version. Who else can claim such a record? But what few, if any of you know, is that Bernie's contribution to the law of the sea long predates the convention. According to confidential records that we were able to uncover in the deep recesses of the Dutch archives, Bernie was actually the principal research assistant to Hugo Grotius, and he ghost wrote large sections of Mare Liberum, Freedom of the Seas. But as we all know about Bernie, he is too modest to claim credit for that treatise or any of the many brilliant accomplishments that actually do fill his CV. What about Bernie the person? If you want to undertake Mission Impossible, go try to find someone who has an unkind word to say about him. You won't succeed, because Bernie is one of the kindest, gentlest, generous spirited, and most decent human beings you will ever meet. He's just a wonderful guy. Everybody loves him. He's even my own wife's favorite American international lawyer. And he's mine too. I was blessed to be his colleague in the Philippines-China arbitration over the South China Sea. You could not conceive of a better colleague. And it was a privilege and a great and unique learning experience to observe Bernie engaging with Rudiger Wolfram, last year's Hudson Award winner, Tom Mensa, Jean-Pierre Cote, and other distinguished experts on the tribunal over interpretation of fundamental provisions of the 1982 convention. I've also had the good fortune to appear before Bernie in his capacity as a judge in Bangladesh, Myanmar, and Mauritius, Maldives. He combines a mastery of the law with an admirable judicial temperament. As a member of a tribunal, he's a consensus seeker and builder. Remarkably, he often manages to co-author a separate opinion with the judge ad hoc appointed by the other party. How can we explain this? Because he is not only a superstar international lawyer, he is a superstar human being. I am very proud to have him as a friend and extremely happy for him today. Congratulations, Bernie. We love you. And now we will turn the proceedings over to Professor Laurie Damrosch, former colleague of Bernie's, who has promised an enlightening and revealing interview with our award winner.
Thanks so much, Paul. This is such a pleasure for me to conduct this interview. Indeed, I have known Bernie for a very long time, first by reputation and then directly. So I joined the Office of the Legal Advisor in September of 1977, and that was just as Bernie was leaving that office to take up his academic post at the University of Miami, and his reputation was already legendary. I didn't have much need in my first years in the office to immerse myself on law of the sea, but he was obviously the go-to person, and everyone in the office was already singing his praises, and I didn't even meet the guy until sometime later. So when did our paths first begin to cross? As I recall it, we were introduced by our shared mentor, Jack Stevenson. This would have been in the mid-1980s in the aftermath of the Nicaragua case. And I had just joined the Columbia Law faculty. Jack reached out to me and invited me to organize an academic study on the International Court of Justice in the aftermath of Nicaragua. And in formulating our list for the very first scholars that we wanted to reach out to, Jack said, "You've got to get Bernie on your team because he knows everything about provisional measures." So this is not a topic on law of the sea. This is a topic on international adjudication. So we brought Bernie into the study of the International Court of Justice at a crossroads, and we'll be talking a little bit later about provisional measures in various international tribunals. That collaboration was such a success that when I then organized another study group for the society, which was with the then Soviet Union, the Soviet Union did not endure as long as our project endured, but Bernie and I got a wonderful trip to Moscow about it. So Paul, I want to compare you anecdote for anecdote about what it's like to be traveling in foreign places with Bernie, because I remember a lot of things about our trip to Moscow, including our visit to the Moscow Conservatory and a few things about the academic pension where they put us up. In any case, we then, by this time, our collaboration was pretty fully fixed. And by the time I was invited to join the board of editors of the American Journal of International Law, he had been on it for quite a few years already. So he welcomed me to, I want to say, that fraternity. He became, some years later, the international decisions editor of the American Journal. And toward the end of that period of his career, about, let's see, when is this going to be? This would be the year 2013. We formed a team and we were selected by the board of editors to become the co-editors in chief of the American Journal. So we had 10 years together. We talked at least once a week, maybe more often during that period, and got to know each other pretty well. So against that background, and bearing in mind all the highlights that Paul has mentioned to you and a few other highlights that I'm going to dole out along the way, I want to go back to Bernie's earliest days. He was born in New York City. He grew up in Brooklyn. I'm sitting right now in Brooklyn. He studied at Columbia in the 1960s for both college and law school. That happens to be the law school where I've been teaching for a while. So the first question that I want to put to Bernie has to do with his New York years. During your time in Brooklyn or during your time at Columbia, either college or law school, were you already being drawn toward international law? Did you study international law at Columbia Law School? Did any of your professors influence you or encourage you in this direction? Speak.
The answer is yes. First, let me thank you, Laurie, and thank Paul and thank Catherine for the very, very kind words. I'm not sure that I can recognize the person that you were talking about, but it sounds like someone I would like to meet. My interest in things international actually began as an undergraduate, and one of the things that stood out was that I took a course in nationalism in sub-Saharan Africa as an undergraduate, and that very much piqued my interest in international affairs. I barely begun my studies at Columbia Law School when the Cuba Missile Crisis was upon us. As you might imagine, the talk of nuclear annihilation did catch my attention. Subsequently, after completing my first year, I did study international law at Columbia Law School with the legendary Wolfgang Friedman, who was a spectacular teacher. I do recall that he used the bishop's then famous casebook with monumental notes, all of which I tried to read. And Friedman definitely piqued my interest in international law. Among other things, his lectures included very lively critiques of Myers-McDougall and what came to be known as the Yale School. And that caused me, in turn, to check out what Mac had to say as well. And that further piqued my interest in international law. During the law school period, my interest in international aspects of the law was not limited to public international law. I also studied the civil law system with Henry DeVries. I was his research assistant. And my job was to work on updating his short book, that introduces the French legal system. That book was co-authored with the prominent French scholar René David. The book had gone to press shortly before the adoption of the then new French Fifth Republic Constitution. And so you can imagine that therefore was the principal focus of my work on updating. There were also other inspirations. My encounter with Lou Henkin while I was at Columbia was focused on constitutional law rather than international law. But by the time I was working in the Pentagon after law school, he acquired an enduring influence on me that lasted throughout my career.
Great. Well, I'm glad you gave all the right answers to those questions about your background, including that you mentioned your work as a research assistant in the French language, because Paul has highlighted the role that you played in bringing to completion and to perfection the English language text of the Law of the Sea Convention. But I would venture to suggest that the superlative legal diplomatist needs to know French almost as well as English, and I'm sure that that is true in your case. So, so you graduated from law school, and then you found a job. I gather it was with the Navy Judge Advocate General Corps, and I just wonder if you could give us a few words on how you came to apply for the Navy JAG position and how you found your way into the field of international law through that particular route.
Yes, well, when I graduated from law school in 1965, we were in the midst of the Vietnam War, and my graduation not only signaled the award of the degree from Columbia, but it also signaled that my deferral from the draft would come to an end. And my options in that situation were limited. I had heard about the Navy JAG program, and I decided to apply. I was accepted, and in fact, I was commissioned by the Navy just in time to preclude the Army from drafting me, and I had the pleasure, I'm sure Paul would have enjoyed this as well, I had the pleasure of sending them a letter citing the statute that prohibited them from drafting members of the armed forces. As my training in Newport was drawing to a close, two very fateful events occurred that really do presage the future course of my careers. We can probably use the plural. I received orders to report to the Office of the Judge General of the Navy in Washington. But at the same time, the Naval Justice School, where I was studying, invited me to remain there and to teach. And I had to make a decision. By this point, I had become quite interested in questions of international law, but I was told that it was very unlikely that the Judge Advocate General's office would assign a junior officer fresh out of Naval Justice School to the International Law Division of the JAG office in Washington. I nevertheless decided to give it a try. And so I called someone at the personnel office in Washington. I explained to them that I had orders to come to Washington from the JAG office, but that I was also invited to stay and teach, and that I really wanted to know whether they would be assigning me to the International Law Division, because if they were, I would be inclined to come to Washington. If not, I would be inclined to stay in Newport and teach. And the individual said that he would have to check the file. And the real question was whether I had reached someone who understood why I was really making the call. And I stood in the phone booth. I can remember this. Most of you watching now don't know what phone booths are. It was a coin-operated telephone. It was freezing in a phone booth in Newport, Rhode Island, in February. And I'm putting quarters, which was a lot of money for a phone booth at that time, in while I wait to get a response. And indeed, I was not certain that my supply of quarters would in fact last long enough. But sure enough, after a substantial period of time, the individual in the personnel office came back, said he had my file in front of him, and the file said that I was going to the International Law Division of the Office of the Judge Advocate General of the Navy. And so I went to Washington. I showed up in that office. My first job, I remember, was to draft documents leasing a destroyer to Brazil. But shortly thereafter, the Soviet Union delivered a note, diplomatic note to the United States and a number of other countries, inquiring as to whether there would be interest in convening another global conference on the law of the sea for the specific purpose of agreeing on 12 nautical miles as the maximum permissible breadth of the territorial sea. The Secretary of State, as you can imagine, wished to elicit the reaction of interested departments in the government, which of course would include the Department of Defense, and therefore sent a note with an inquiry over to the Secretary of Defense. For those of you who have worked in large bureaucracies, you know what happens next, and that is that the inquiry went from the Secretary of Defense to the service secretaries, including in particular the Secretary of the Navy and the Chief of Naval Operations, and it went from them to the Judge Advocate General, and it went from the Judge Advocate General to the head of the International Law Division in the Navy JAG office, and proceeded on its way down until it reached the absolute bottom from which it had no further to go, which was my death. And it became my job to organize what became a huge multi-month study within the Pentagon of whether we were prepared to move away from the position of the 3-mile territorial sea that had been first announced for the United States by Thomas Jefferson. This was a very daunting task. I was very fortunate to be able to have significant advice and guidance from Admiral Wilfred Hearn and Admiral Joseph Devitt during that period in order to navigate my way through the Pentagon without having my head chopped off. As some of you may know, the end of that process was that the Department of Defense informed the Department of State that it was prepared to support further discussion with the Soviet Union on the matter on condition that freedom of transit for all ships and aircraft through straits overlapped on the territorial sea would be expressly preserved. And that's the beginning, as it were.
That's the beginning. That's the beginning. So then we want to move to the next step, which is that I gather from your CV that after a few years at the Pentagon, or maybe shorter, I don't have the date right in front of me, you moved across the river from the Pentagon over to the Department of State and into the office of the legal advisor. So how did you move from the International Law Division in the Pentagon to the Law of the Sea portfolio at State? And who were the main influences on you in your time at State?
It was a surprise. In the course of my Navy service, and I'm very proud of this, I received a Navy commendation medal. And when I read the citation, it did seem to me that the real purpose of awarding the medal was for valor in battle against the State Department. Seriously, though, not all of my contacts with the Department of State involved disagreements between my client and the Department of State. While I was in the Navy, I was very privileged to have the opportunity to be of some assistance to Steve Schwabel, who at that time had been asked by the State Department to handle the very difficult and persistent issue of claims by Micronesians against Japan and others, largely for injuries suffered in the course of World War II, in part as a result of the unlawful arming of the islands of Micronesia in violation of the mandate. That was the beginning of an enduring and immensely rewarding and influential relationship, so far as I'm concerned, with Steve Schrebel, who was a towering figure in international law and whose wise counsel I, of course, continue to rely to this day. That said, like many Columbia Law graduates at the time, I thought that I would be going to a Wall Street law firm. Indeed, at the end of my second year of law school, there had been some offers of summer jobs at Wall Street firms, and I consulted Herbert Wexler at the time, who told me to decline all of the requests and travel abroad for the summer because this would be my last school long vacation opportunity to do so, and that what I should do is expose myself to foreign languages and cultures on the assumption that I will then have ample opportunity to expose myself to law. And that's what I thought I would be doing. And so I was really quite surprised when in the fall of 1968, as my active duty commitment in the Navy was coming to an end, I received a telephone call from the then legal advisor of the Department of State, Leonard Meeker, who inquired whether I would be interested in coming to work in the legal advisor's office. After some hesitation on my part, I accepted that offer. The Johnson administration was coming to an end soon thereafter. And sometime after that, John Stevenson, who you referred to already, Laurie, became the new legal advisor of the Department of State. And soon thereafter, he assumed principal responsibility for the law of the sea negotiations within the Department of State and eventually within the executive branch as a whole. And I worked directly with Jeff Stevenson in that capacity. It was an extraordinary privilege from which I learned a great deal, including, to add a moment of levity, I learned never to leave the original document alone with him on his desk. When Congress created a new Bureau of Oceans, Environment, and Science within the Department of State, Stevenson sought White House approval to name me as the assistant legal advisor responsible for providing legal advice both to the new Bureau and to the interagency process working on the law of the sea. And I want to add that it was also Stevenson who created the position in the legal advisor's office of counselor on international law and who persuaded Louis Sohn to be the first person to hold that position. And Louis Sohn was thus drawn into the law of the sea circle by Stevenson, and I in turn had the opportunity to work closely with Louis as well. As you can see from this pattern, I have been extremely fortunate in the people I've had the opportunity to work with in the course of my career. And I definitely want to make clear that I include within that both you, Laurie, and Paul, who have been fascinating colleagues to work closely with.
Thanks. Well, we now want to turn to that period in which the Law of the Sea conference was active, the period from 1973 to 1982, when you were working initially with Stevenson, and then later with Elliot Richardson in the U.S. delegation. I gather you were the vice chair of that delegation, and as Paul has already mentioned, the chair of its English language drafting committee. So from that period of roughly 9 years or so, are there any reminiscences or anecdotes that you would like to convey about those experiences?
Well, as you know, Laurie, I've had ample opportunity to address the substance of the negotiations in my writings, in mostly in the American Journal of International Law, but elsewhere as well. And in fact, my most vivid memories, this is a wonderful question, are of the extraordinary people, both Americans and foreigners, with whom it was my privilege to work closely. There are far too many to mention by name, and that speaks volumes about my very, very good You mentioned Richardson, the opportunity to spend years working directly. The towering figure, really, of unwavering character like Elliot Richardson simply cannot be duplicated. One of Richardson's observations about the law of the sea negotiations was that influence in a complex multilateral negotiation is not exclusively contingent on the influence of the country that is being represented, but may also depend as well on the quality of the representative. And this is extremely important insight. I could cite many, many examples. One clearly good example in the law of the sea negotiations was my good friend Tommy Koh of Singapore, whose uncommon ability propelled him to the presidency of the conference itself in its climactic years. The other recollection is the challenge of coordinating a huge delegation like that which was sent by the United States to the law of the sea negotiations over a period of many years. Our delegation included not only representatives of a very large number of federal government agencies, but members of Congress and congressional staff, as well as public members who represented a variety of different interests, a variety of different non-governmental organizations, and even religious organizations. I do remember that a Wall Street Journal reporter who was not necessarily favorably disposed to these negotiations once asked me about the ample size of the US delegation at the first substantive session of the Law of the Sea Conference, which took place in Caracas. And I do recall that I replied that in a spirit of participatory democracy, we brought our country with us. I do remember, for example, that Jack Stevenson once reported to me on the conversations he had had with the then chair of the Group of 77, the group of developing countries, who was complaining to Jack about the difficulty he had of coordinating all of these different positions of these different countries. And Jack, of course, replied and said that it's nothing compared to the challenges that I face in coordinating all of the different interests within the United States that are represented on our delegation. It was not by any stretch of the imagination a simple operation, and the conclusion that there would be a convention adopted that would in fact be widely accepted was not foregone. Shakespeare, it took very, very hard work and a good deal of imagination on the part of many.
Great.
Responses.
Okay, I want to move to the phase of your career that's the scholarly career, both your contributions already mentioned to the American Journal over many years through the series of articles explaining the stage of the negotiations of the Law of the Sea Convention and conveying what it was all about, and for this extraordinary series of articles from 1974 into the 1980s, you were awarded the American Journal's Francis Dayak Prize for the best contribution by a younger author. And then moving ahead, couple decades, I guess, when there came to be an inflection point for the Law of the Sea and the preparation of the modification agreement, the implementing agreement for Part 11, that basically resolved all of the objections or concerns that the Reagan administration had raised about the 1982 convention. I think your 1994 article laying all of those concerns to rest really holds up beautifully as the best piece for explaining to anyone why those older objections to the initial treaty have been solved in the modification agreement. And I continue to recommend that to all of my students. You joined the University of Miami faculty, as we've heard, and in 2007, when you were designated to the Richard Hausler Chair, I had the privilege of coming down to the University of Miami for a symposium event on what was then your most recent article on the law of the sea. It was your centennial essay contributed to the American Journal called The Territorial Temptation, a Siren Song at Sea. And we had a lot of fun thinking about temptations and sirens and Homer and Ulysses and all sorts of classical images. And I would really recommend that article to anyone who's looking for a very readable overview of a century of scholarship and practice on law of the sea, and also why we should resist temptation. So I would give you the opportunity, Bernie, to explain why we should resist temptation, but I want to move ahead to what I think is going to be the most interesting feature of your career to many who are listening today. And that has to do, first, well, with your scholarship on peaceful settlement of disputes, which is not limited to peaceful settlement of disputes on law of the sea. It's really a wide-ranging scholarship on peaceful settlement of disputes. And then your role that Paul Reichler has mentioned as counsel, arbitrator, and judge ad hoc of the International Tribunal for the Law of the Sea and of the International Court of Justice. And I was going to mention the same thing that Paul has already mentioned, but I'll elaborate it a little bit. So the Law of the Sea Convention sets up these three pillars of dispute settlement, arbitration, the International Tribunal for the Law of the Sea, and the International Court of Justice. You have served as an adjudicator in all of those roles, in an arbitral setting, as a judge ad hoc of the International Tribunal for the Law of the Sea, and as a judge ad hoc for the International Court of Justice. And you've also served as counsel in arbitrations and at the ICJ. And as Paul mentioned, I believe that we are both correct, that you are the only American to have served as a judge ad hoc for both the International Tribunal for the Law of the Sea and the International Court of Justice. So Catherine quoted a passage or two from a letter that several of us submitted to nominate you for this Hudson Medal, and she didn't single out the aspect of the letter that refers to really your unique role as a judge ad hoc, both at the International Tribunal for the Law of the Sea and subsequently at the International Court of Justice. Our letter put it that you really reinvented the role. Paul alluded to this. Paul mentioned how by joining together with another judge ad hoc and uniting in a single joint opinion of two judges ad hoc, you could do something totally different from two judges ad hoc who would be reciting the positions of the parties who appointed them. And I'd also want to mention that for the ICJ case on which you served as a judge ad hoc, the judgment of the court in that case was absolutely unanimous. No separate or dissenting judges by anybody, not by either of the judges ad hoc. And I think that's really a tribute and a testament to your consensus building qualities. So I would be delighted to have your reflections on what it's like to sit as a judge ad hoc. I know you can't tell us anything about confidential deliberations, but maybe you can tell us about the size and shape of the table, or maybe you can tell us about the lunchroom, or maybe you can tell us about any aspects of your experiences that would be enlightening for our student audiences or for any of us who are interested in the roles of these tribunals in the peaceful settlement of disputes.
Wow. Well, on the last point, architects, of course, make this point that physical arrangements will make a difference. At the time that I served, the International Court of Justice had a modern, relatively new, circular table in its deliberation room so that most of us could see everyone else. But on the other hand, it was in a splendid, splendid Great Hall of Justice, which nevertheless didn't work all that well in terms of the modern facilities that are used by counsel to better explain the cases to the judges, and I'm not sure that the improvements that they've made in this respect since then at least satisfy my aesthetic attitudes, but that's neither here nor there. The situation in Edlos was exactly the opposite, as it were. The courtroom is absolutely splendid. It is large. It is circular. Wherever you sit, you're looking directly at counsel. You have all of the electronic facilities immediately at your disposal. And in fairness, of course, the Edlos facilities are built in a period when people were already interested in using electronics. The Great Hall of Justice in the Peace Palace was built many, many years before that. On the other hand, the deliberation room had a very long table. And the deliberation room, you have the president and the registrar sitting at the head of the table, so they could in fact see, which is very important, everybody else. And you were then seated by seniority. The effect of that is that the judge or judges, in the case in which I sat, ad hoc are sitting at the other end of the table, either across from or next to each other. It didn't much matter. We were, of course, also the only others in the room who actually had a view of everybody. And there was a tendency, it afforded you an opportunity. It was not the only opportunity, but it afforded you an opportunity to get to know each other. In the land reclamation case, which was at the provisional measures stage, the other judge ad hoc was Kamal Hussein. We had not had the opportunity to work together before, and we did then. Now, it didn't occur to either one of us that we would be breaking precedent, as it were, by ending this with a joint declaration. We did both support the judgment, the provisional measures order of the tribunal, and one about which I wish more could be written, given the fact that this was an interesting environmental case. But we faced something of a technical issue, and it's a nice illustration of how something like this can happen. The International Court of Justice had a practice in its provisional measures decisions of including a sentence that said that this was without prejudice to the merits or to jurisdiction. And that formula sentence appears routinely in International Court of Justice decisions. The difficulty here is that the jurisdiction of the International Tribunal for the Law of the Sea in the case was limited to provisional measures pending the constitution of an arbitral tribunal. The Law of the Sea Tribunal did not have jurisdiction over the merits and over questions of jurisdiction on the merits, but the two ad hoc judges had already been appointed to the arbitral tribunal that would sit on the case in the merits. And therefore, we felt at least that there was an argument that we should follow the precedent of the International Court of Justice and indicate, at least for ourselves, that this was without prejudice to any question of jurisdiction or the merits that would be scheduled to come before us as members of the arbitral tribunal. And that was, in fact, the genesis of the idea that we might say something together that was relevant to our future role in the case, but was not directly relevant to the role of the tribunal. And that emerged into a joint declaration in which we, in fact, went on and said some other things that I've always hoped proved helpful. You've had, I think it's fair to say, you can read it for yourself, that you had both ad hoc judges having nice things to say about each of the parties. And one hopes that in some way contributed to cooperative implementation of the very creative provisional measures order in that case. And the provisional measures order in that case, in fact, once it led to the studies and report that were required by the order, brought the parties to a situation in which they could settle the case, which is a very desirable underlying result. Similarly, in my service on the International Court of Justice in the Black Sea case, neither I, and I suspect perhaps no one else, that I don't know, imagined that we were going to end the case with a unanimous judgment and no separate opinions. There's no way to know at the outset, and you simply approach the case with an open mind. It is clear that one of the interesting aspects of maritime delimitation cases is that the underlying standards for maritime delimitation, both in the text of the Law of the Sea Convention and as articulated by the International Court of Justice and other tribunals in their opinions, is a relatively flexible one. There is not only one boundary that can be said to satisfy the legal requirements. There are a range of possibilities. Judge Wabel, in one of his opinions, makes this point very elegant language. And therefore, you could expect one of two things to happen. One is that you could have a situation, which would be rather chaotic, in which you had 15 judges with 15 opinions supporting 15 boundaries, all of which could rationally be said to satisfy the criteria. Or the other is that there would be a wide range of possibilities for assembling a group that felt that the outcome satisfied the legal criteria. Those legal criteria, in the words of the Law of the Sea Convention, have to include an equitable result and come together, as did happen in the Black Sea case. And Black Sea case also has to be seen in context as the culmination of a reaction of both the International Court of Justice and other tribunals to initial articulations of this process in earlier cases. And of course, one of the many functions of judges in cases is to develop some concern to the question of precisely how the law on the topic should be articulated and developed for the benefit not only of future tribunals, but for the benefit of governments that will try and implement that law in other situations. And these are many things that one would think about. Now, it is true, therefore, that the end result in the Black Sea case was not something that I believe Chateau Rosen is the one who said that had really happened before, and that is a final judgment on the merits with two ad hoc judges on the court, right? And no separate opinions whatsoever. And again, that, like the joint declaration in the land reclamation case, and there were subsequent joint declarations, is, I think, has to be attributed in many ways to the extraordinary individuals who are also serving as judges ad hoc in the cases in which I was appointed, and indeed in cases in which I'm serving now. That were it not for the character, imagination, abilities of these individuals, I'm not sure that any of these changes would have occurred. And obviously, I do think that they are for the better. I didn't set out to reform the system. But when I was appointed a judge ad hoc, I obviously tried to do some reading and research that included Steve Schreibel's article on the subject. And I pretty much decided that, like Manley Hudson, I did not agree with Hirsch Lauderpacht's criticisms of the institution of judges of the nationality parties or ad hoc judges. But I did agree with Lauderpacht that the point of departure and point of analysis is the solemn declaration. And I do want to emphasize this. Article 20 of the RCJ statute requires every judge, including the ad hoc judges, to make a solemn declaration, exercise his or her powers impartially and conscientiously. And Article 11 of the IFLAS statute says exactly the same thing. You don't have that requirement with respect to arbitration under the Law of the Sea Convention, or typically, but I would point out that the qualifications for being on the list of Annex 7 arbitrators under the Law of the Sea Convention is that a person must enjoy the highest reputation for fairness, competence, and integrity. And I think if you start out there, then you have to reach the conclusion that the kinds of sharp distinctions that may have been drawn between ad hoc judges and other judges are not necessarily the only way in which to interpret their role. You can make an argument that the ad hoc judge should try to ensure that the arguments made by the appointing party have been fully and fairly heard. And I have to say, in my very limited experience, I've only served on a few cases, that this is rarely a difficult or onerous task. There's very widespread agreement with the underlying premise that each of the parties arguments should be fully and fairly considered, right? And there's in fact very widespread agreement that the judgment itself has to make clear that that this has been done. And while there are others who have a different view, I remain personally to be convinced that an individual opinion by an ad hoc judge favorable to the appointing party adds significant reassurance in regard to this question. That said, of course, every case has to be approached with an open mind, both on the merits and in terms of the conception of how one envisages one's role in the process, and you can't come in with a priori notions of precisely how that is going to develop. Indeed, law professors, or at least this law professor, have to remember that the process of being a law professor is very different from the process of judging. A lot of people have written on it. It's very important that it be borne in mind.
This law professor has the eye on the clock here, and I'm afraid we're going to be cut off at 1:30. And before that happens, I want to say a few things. First of all, there's a separate link to continue the conversation segment, so that Bernie will be available starting from the close of this program for about half an hour, as will I, for those of you who would like to pose questions directly to him. In this Zoom format, we didn't receive questions as could have possibly been accommodated, and we're quite short on time. But before we go, I do have a couple of final remarks. In the letter that a whole lot of us joined, every living president of the American Society of International Law and all but one of the living Hudson medalists. We couldn't track down one stray one, but we got almost all of them to endorse our honoree today as not only deserving of the honor, but really the most deserving, and on so many different dimensions of being a scholar, of being a practitioner, of being an arbitrator, of being a judge. And on this last point, the point Bernie has been speaking to about the role of the judge ad hoc, I think there's a very revealing comment or set of comments in our own American Society of International Law proceedings when Judge Rosalind Higgins, who has spoken at a number of our annual meetings and spoke in 2001, was speaking about the role of the judge ad hoc in general, and then the particularly stellar examples. And she started out by saying that the role is as a security blanket to states in front of the court. Okay, so that's the generic. But then she says there are two sorts of ad hoc judges who are really especially useful for the court. And one is when you have judges, I'm quoting here from Judge Higgins, when you have judges who are really and truly experts in a particular field. For example, in her last case, Judge Higgins' last case as president, Romania versus Ukraine, the court got a tremendous bonus from having Bernie Oxman and Jean-Pierre Cote. They both knew so much about the subject, and you could not have told in the discussions and in the help they gave us who had been appointed by which party. I think that really so well illustrates the point that Bernie has just been mentioning about how the judges ad hoc, like all members of the tribunal, take that solemn declaration very seriously and are doing the utmost in fairness and impartiality and independence. So I would just end up by quoting the last sentence of our letter, that we, the nominators, believe that Bernard Oxman is among the most distinguished international lawyers of his generation, and that the society would honor itself, as it has in fact done, in awarding him the Manley O. Hudson Medal. So thank you so much for the honor of being able to interview today, and I turn the floor back over to Catherine Amirfar for concluding remarks.
Thank you so much, Lori. Thank you so much, Bernie. I think the stories that we heard today are a real testament, and I think bring to life why this is such a well-deserved recognition. And frankly, Bernie, why you are so beloved by this community. So just a congratulations again to everyone. Thank you so much for joining us. Please do join us at 3 p.m. Eastern for the presentation of the Butcher Medal to the Honorable Louise Arbour. In the meantime, as Lori mentioned, there is a button that says continue the conversation so that you can join us and chat and congratulate Bernie directly. So thank you everyone for this magnificent program, and congratulations again. We'll see you soon.